Welcome to the channel of the Incomparable Faculty of Law, University of Lagos. My name is Professor Adekile, and I will be taking you through the thoughts of public nuisance. This presentation has the following learning outcomes. Number one, to understand and identify the types of interest protected in public nuisance. Discuss the components of public nuisance. To state examples of public nuisance. You will also be able to identify those who may sue and who may be sued in public nuisance. You should be able to explain the concept of particular damage and know the relevance of having interest in land. Finally, a student of this topic should be able to state and explain the remedies that are available for public nuisance. Now, we already underscored the fact that public nuisance generally is a law, is a tort that protects the lived environment, that protects interaction with your property and the implication of that interaction with your neighbor's land, with your neighbor's use and enjoyment of land. So sometimes they describe it as indirect interference as compared with trespass to land, which deals with direct interference. The essence of this tort is the protection of the use and enjoyment of land. And a good student of the tort of nuisance generally should be able to bring out the distinctions between the tort of nuisance, trespass to land, negligence, and its rule in Rylands and Fletcher. I'll just go straight to looking at the question of the types of nuisance. Usually we talk about public nuisance and private nuisance. In public nuisance, which is the focus of our discussion in this video, you're talking about a nuisance that materially affects the reasonable comfort of a class of the society. Reasonable comfort of a class of the society. And you can see the case of Attorney General against PYA queries. And you may describe that nuisance as large-scale nuisance. For instance, a group of people or somebody might decide to have a musical concert or a sports festival or sports competition, and it causes so much noise or so much influx of people or causes so much traffic. Okay, sometimes you have religious gathering in society that cause so much traffic on a large scale, and you have blockage of roads with some by vehicular movements, or sometimes someone just decides to dump building materials on the road, efforts to build their property, and there is no access to that road, or there is reduction of movement, or holding large-scale parties amongst others. But we are talking generally, therefore, of things that affect a class of the society, not just two property owners between themselves. Now, in terms of defining it, therefore, you might say that it is an interference with public use or enjoyment of public rights, public use of or enjoyment of public rights. It is an act that endangers the life, the health, or property or comfort of the public, not just two individual public property owners now, but something that can be said to have been escalated to a class of the society generally. And it's usually located in common law and statutory frameworks. For instance, in terms of the protection of the highways and these public spaces, you have legislation on highway. Apart from highway legislation, you also have it located in statutes that protect the environment. In fact, this is one of the foundational thoughts that deal with environmental protection. So statutes that deal with environmental protection are also reflection of some of the issues in public nuisance. Public nuisance, and this must be clearly emphasized, is actually a crime. It's a crime. It's an offense. And the power to litigate it is located in the Attorney General. It's a crime against the state because it's something that affects the general public. And the rationale for this being a crime and making the Attorney General the person that has the power to come to court and remedy it, and is the fact that because it affects a class of the society, if you allow everyone to sue, you have multiplicity of suits. So it is actually fundamentally regarded as a crime. And the only situations where private persons may sue have been recognized as where a private person can show that they have suffered particular damage, which I'll be explaining soon. Now, you must understand as that the components of public nuisance include the fact that there must be possibility of the risk of damage. You remember the case of Ragomand, assistant of tort law. You should be familiar with the case of Ragomand in the tort of negligence. And then you have the case also very significant, Cambridge Water Works against Easter Counties, which clarify the position with regards to the possibility of nuisance claims, that foreseeability is also important. It is that foreseeability where you can foresee the injury that makes you to realize that what you are doing is unreasonable. Okay, if you, for instance, pack a load of sand or gravel on a public street, on a highway, it's reasonably foreseeable that you obstruct traffic, vehicular movement. So it's also applicable in nuisance generally. The persons that are affected in public nuisance, this is one of the core areas that you can be examined upon, because it's not just between private individual property owners. You talk about a nuisance that affects the reasonable comfort and convenience of the public or a class of the public. The general public, which may mean the whole of Nigeria or the whole of Lagos State or a local government, or a class of the public. You can see for this point, Attorney General against PYA queries, where there was a complaint that vibrations from querying activities caused noise, dust, and other inconvenience. And the court held that that was a case of public nuisance because it affected the society generally, the people that were in that location. Then you have the case of Cambridge Water Works that I mentioned earlier. In Nigeria, you have a case like Savage and Animation, where there was obstruction of the road. And this case is quite interesting because it also gives us the context of particular damage. And because of the road obstruction, there was, the vehicular movement was impeded. And the court held that the plaintiffs in that case had suffered particular damage, which I will explain. Now, what are the examples of public nuisance so that we can have a graphic understanding, a clear understanding of what we are talking about? Usually, public nuisance are activities that affect public health, safety, and comfort. For instance, when you sell food that is unfit for human consumption, that can cause a breakout of diseases, when you keep an unhealthy house, when you have industrial pollution by a handful of toxic fumes. There was a time in Nigeria that some people came to dump toxic waste in Nigeria, in a town called Koko. When you keep unhealthy house, when you have when you have something like smoke or foul odors in a neighborhood, maybe because of poor sewage disposal methods, where you pollute the rivers and waterways, and you do not allow people to have water for human consumption. So you have things that affect the health of the public in general as constituting public nuisance. Then you have those that affect the public morals and public decency. For instance, keeping a brothel and encouraging the influx of miscreants and, gambling and all those activities that create, a discomfort to the general public. That's another example of public nuisance. Then you have activities that obstruct the roads, closing the highways. In Nigeria, when I was growing up, you have night parties. Most of these night parties, we didn't have the concept of event centers then. You either hold a party in your house or you hold it on the street, and you have to block the streets. So you have vehicles that are coming and then get to a place and realize on a Friday that they're having a party. Unless you have the permission, the requisite permission, that would be a classic case of public nuisance. Who can sue? The persons that can sue include the Attorney General, a local government authority, if authorized by statute, or some cases, private persons. Like I said earlier, the Attorney General has the primary right to sue for public nuisance because it is a crime. Students of criminal law, you know that crimes are regarded as actions against the state, and the state is the one that prosecutes. So the same goes for public nuisance. Attorney General and PRW queries that I have mentioned many times. Then you have the case of Hunter and Canary Wharf, where they complained about not being able to interference with TV reception was not permitted because it was not a nuisance, and the court said that even if it was a nuisance, that the only the people that have interest in land can sue. Now, when you talk about those who can sue, then you have private persons. The initial position at common law is that a private person may sue in public nuisance in some situations. While we have underscored the fact that the Attorney General has the primary right to sue, in some cases, it is allowed for private persons to bring an action in public nuisance, rather, where the number one, where the person has suffered particular damage. Number two, where the interference is with a public right, you know, interference with public right affects that person's private rights. And thirdly, where there's a threat of damage to that person's property. I'll take that one about particular damage. What do we mean by this? What we are saying is that a person must be able to show that their own damage is peculiar, is special, is over and above the damage that others in the society have suffered by virtue of that activity of the defendant. For instance, the obstruction of the highway. That what I have suffered as an individual is more than what others have suffered. So you're talking about special loss or damage than what the general public have suffered. You might see in this case, the case of Amos and Shell BP, and the case of Adedimo and Interland. And if you are a student of nuisance of the sort of nuisance in Nigeria, you must just know these cases that I've mentioned. Adedimo and Interland in particular, hitherto under the Nigerian law, it's usually held. It had always been the case that it is said that a private person cannot bring an action without obtaining the consent of the Attorney General to bring that action. But by the time the case of Adedimo and Interland was decided in 1992, the court decided that you do not actually need the consent of the Attorney General, because the Constitution gives everyone the right of access to the courts under Section 66B of the Constitution of 1979 Constitution. By virtue of the decision in Adedimo and Interland, private persons can bring a cause of action if they can show locus standi. They can prove that they have locus standi by demonstrating that they have suffered particular damage, a damage that is over and above what others have suffered. And I would enjoy you to look at that case, the facts, and get yourself familiar with that case. Then the concept of particular damage, you're talking about the fact that you also have mentioned other cases like Savage and Akinriyade earlier on, Winter and Derry, and then Rose and Miles. Particular damage could be financial damage, it could be loss of business or profits, damage to property, something that is different from what others have suffered. In the case of Savage that I mentioned earlier, it's interesting in the sense that even though there was a blockade of the road, the court held that the parties that brought the action had suffered particular damage. One was an 85-year-old woman who was not able to access her house and had to go through a very long route to be able to get to her property. And the court said, considering the age of that person, the inconvenience that she has suffered by not being able to have access to that residence was over and above what ordinary people in society have suffered. Then the other person who had a school, and the students, the staff, and the parents were not able to easily access the school. Recently, you see so many construction works going on. Unless they can prove some statutory authority or whatever, these are things that could actually constitute public nuisance if there is no legitimate basis for these activities and the interest of the people affected have not been taken care of. Nuisance and interest in land. Now, I said in private nuisance, parties must have interest in land, both the plaintiff and the defendant, a legal interest. Either you are the owner or the occupier of that land, or any of the two lands that are in contemplation. In public nuisance, you may not, as a plaintiff, be the owner or occupier of a land, but the injury that has been suffered must arise from the use of land, because nuisance is about land rights. It's about land rights. So while you may not be said to be a landlord or occupier or whatever of land, the interest, the damage that has occurred must arise from the use of land, whether you are driving on the road or whatever. What are the remedies? I've always emphasized, and I will emphasize this: when you look at a tort, you look at the remedies, because that's what is interesting to your client. He wants to know, what can I do? What can I actually do? I'm going to espouse the law. You can try to obtain an injunction. The Attorney General can can obtain an injunction, or a private person can obtain an injunction to stop. That's a court order that says that you should stop a particular activity, or that you should not do it in a particular way. You have had cases where, for instance, churches have been told that, okay, you can only hold you cannot hold vigils every day from Monday to Saturday, and have influx of people day and night. That okay, you should do it within, for instance, maybe 10 to 12 midnight. And so the injunction must, the way it is couched is important. Not just that you can stop the activity. Some may be told to stop, some may be told, they may regulate how they use the property in a way that you do not infringe on the right of the plaintiff, and you do not infringe on the right of the defendant. You may also claim damages and abatement, self-help in some limited cases, unless a plaintiff is able to show, of course, particular damage that we have talked about earlier. Most plaintiffs may have to resort to a bit of a self-help, like removing the obstruction on a public way when you want to drive across that way. Then you have the criminal proceedings that can be brought against that person, because we said that public nuisance is a crime. In summary, therefore, we have said that nuisance affects the social interaction of people, it protects the lived environment, and it tries to regulate use and enjoyment of property in a way that it does not affect neighboring landowners. And with respect to public nuisance, we said it's a kind of nuisance that affects a class of the society. It goes beyond its escalation of private nuisance to a larger scale, so to say. It could affect the health of the public, it could affect comfort, their public morality, it could decency, it could obstruct the public space. So those are the interests that it targets. And the categories of those who could sue include the Attorney General, or private persons, or local authorities, as the case may be. A person that is suing, where a private individual is suing for private nuisance, and this is an area that you could be examined upon, must have suffered particular damage. And by particular damage, we mean a damage that is above or beyond special to what others have suffered, the general public has suffered. And the available remedies are the injunction, damages, abatement, and criminal proceedings against the defendant. Thank you for listening. Don't forget to like this video, to subscribe to the channel, and to share with your friends. And I'll see you at the next presentation.